I opened it.
All right. So I suggest that we keep the blinds open as long as we can. If at any point you can see, you let me know, but let's try to, yeah. So we finished a big part of the course. You'll see that I decided to start with trade law and with WTO law because it's extremely technical and it's way more dense than what we're going to do now. So I kind of started with the most difficult, most complex one. And we only scratched the surface because I only selected some agreements and some provisions. But for any of you who's interested in WTO law, be prepared, like to specialize maybe, or even to work in this area, be prepared that there are so many more agreements and it gets so much more technical than that. But the idea was to start with kind of the most complex, and then I'm not saying that investment law is not complex, but it's a different kind. There are way less provisions, as you will see. The difficulty there is in the interpretation of the jurisprudence. But I wanted, again, to start with the hardest, let's say, and then move down. Now, before we move to this first session on international investment law, I just wanted to, for those of you who have signed up for the visit just to the WTO, just clarify a few points. If you have signed up and at the end you can't make it, it's okay. You can. It's polite if you send us an email, but it's not a big deal. Somebody was asking, I forgot to sign up, can I swap? Sadly not, because it's not an issue of how many. I could have taken 200 of you. It's an issue of they have the names. So unless you want to swap with a person with the exact same name as you, they're going to have a different passport. And we'll see the importance of nationality today when we talk about investors. So sadly not. If you really want to visit the WTO and you miss this opportunity, I will announce once it comes out an open day that WTO organizes every year. It's usually May or June. They open their doors, they have activities, tours and stuff, so it doesn't mean that you won't have a chance to visit the building, okay? And then we will send an email to those of you who signed up this evening with just a few security requirements from them. You have to bring your passport, you need to wear appropriate attire. It's winter. I have issues when I bring my summer school students that want to come in shorts and flip-flops. I think in winter it's less urgent to make this point, but they have some regulations. So we'll share some of those details with you later this evening. All right, so if everybody's ready to start with international investment law, I wanna start, oh no. Let me see if I can make some space. So this is, as you will see, it's an entirely different, it's always part of what we call international economic law, but it's very different. There will be some similarities. You'll find some things that you already know. For example, we will talk about non-discrimination as well. It won't be about non-discrimination between products. It will be non-discrimination between investors. But, so that principle, for example, is going to be very useful for you to already know it under trade law, because you'll see that, some of the things that you've learned can be also useful in investment law. But it's very different because it's not just about states. So trade law is really about states, right? WTO law regulates the behavior of states. It tells states what kind of trade policies they can or they cannot adopt. Disputes are between states. We saw that industries, companies can have a role. For example, they can push a state to bring a dispute if they feel like they've been harmed by the practice of another state, but it's a really interstate system. Investment law is not. The whole system is between states and investors, foreign investors, and foreign investors are private actors. They can be individual, we'll see today, they can be companies, but these are private actors. The whole point about international investment law is to give protection to foreign investors. So you will see, and this has become, and we'll talk about this, one of the main problems today with investment law is that investment treaties have a whole list of rights that foreign investors have, corresponding duties and obligations for states, which means that only the investor can bring a dispute against the state. So it's a very unbalanced system. Everything is in favor of the investor. And we will see that it has created a lot of problems today because the regulatory space of the state has been reduced and reduced and reduced, because whenever states try to do something different, investors complain. And because of, we will see how the provisions of these treaties are drafted, they might have a case, and they often have a case. Now, the kind of situation that we will be looking at is this. You have two states, one state, which is called host state, another state, let's say state B, which is the home state. This is quite logical. Home state is the state of nationality of the investor. So you have a company or an individual, a private actor from this state that decides to conduct an investment in a different state. The host state, because it's the state that hosts the investment. Now, this specific transaction, this investment, usually has two levels of protection. And I will explain in a second why I say usually. Usually you have a contract, an investment contract, between the investor and the host state. Let's imagine that I have a Swiss company. I am a Swiss company. Let's say I want to invest in Argentina. I'm gonna, to develop a solar farm. I'm gonna sign a contract with the Argentinian government or a local government, whatever, whichever level is responsible, a contract that is gonna regulate my investment, right? So that's a private-public contract between the investor and the state. So you have a contract, and you have some rules, some levels of protection there. But then there is usually a second layer, because usually you have a treaty, International Investment Agreement, or IIA, between the two states, between the home state and the host state. We will be studying this. We won't be looking at contracts. Many contracts are also confidential. So I've had some students, I used to teach investment law here at seminar at the law school, and some students wanted to do theses studying investment contracts, and it's very hard, especially in sectors like energy or the military, for example. They're confidential, so you won't find them. So we will be looking at these treaties. I mentioned already these treaties at the very beginning of our class when I talked about the sources. Now we usually use this acronym, in International Investment Agreement, to refer to any kind of international agreement or treaty that regulates investments. But there are different types. You can have, the most popular one are bilateral investment treaties, BITs. We have more than 2,500 bilateral investment treaties. Those are treaties between two countries that only look at investment. Some countries have more than 100. I think that Switzerland has more than 120, with 120 different countries. Some countries have very little, maybe they have 3 or 4. There could be a country that doesn't have any. I can't think of any. So we have more than 2,500. BITs are very short, 14 pages, 15 pages. So forget WTO agreements of hundreds of pages. Each of them has maybe 12, 13 articles. And articles are quite short, quite brief, which also means that they are quite vague, and there's a lot of room for interpretation from tribunals. So that's the first type. So these are bilateral, so between two countries, and they only regulate investments. We also have, when we talk about IIAs, we also have investment chapters in free trade agreements, or FTAs. I mentioned that in the trade law portion of this course, we have looked at WTO law, but we also said, remember when we looked at the exceptions, we said countries are free to negotiate regional or free trade agreements. And we have more than 400 of these. Sometimes they're between two countries, sometimes they're between 3, 4, 7, there's no rule. Yes?
So the 300 are just all the FTAs or all the FTAs that have an investment chapter?
No, so there's more than 400, I think more than 450 free trade agreements. I don't know how many of them have an investment chapters. I would say almost all of them, most of them. There could be some that maybe very old ones, but usually they have a lot of chapters. They have chapters on different types of trade that kind of look like WTO stuff. So you have maybe a chapter on subsidies, on trade, on a chapter on technical barriers to trade. You have a chapter on investment, usually. You also have chapters on environment, on labor rights, sometimes on health, on sustainable development, and we will see what that means for the interpretation of the investment provisions of that agreement. So the investment chapter in an FTA looks like a BIT, but it's a chapter within a broader agreement that has other chapters as well. We have some regional investment agreements, not many. An example that I'll show you in a second is the investment protocol to the AFCFTA. So the African Continental Free Trade Area, for example, has an investment protocol. So that investment protocol is a regional investment agreement. It only regulates investment, but it's for a whole region, not just bilaterally between two countries. And then we have a sectoral agreement, which is in big trouble, which is the Energy Charter Treaty, which only looks at investments in energy. There's only, a certain number of countries, so not all countries are parties to this agreement, but it's sectoral because it just looks at investments in the energy sector, so not in other sectors. So what I want to do, so this is just to give you a sense. So this is the situation that we will look at. And the protection comes, as we said, from contracts, although we're not going to look at those, but mostly from these treaties. And this is what we are going to look at. Something else which is quite interesting is that many countries have what we call model BITs. And I will be showing you a lot of models. Initially, it was just developed countries, especially because initially BITs were concluded between capital exporting and capital importing countries, so developed and developing countries, basically. The first BIT was between Germany and Pakistan, capital exporting and the capital importing countries. Developed countries started developing models. I will show you some. So it's basically a template of how they would want their BITs to look like. For a long time, again, a lot of capital importing developing countries did not have a model. What does that mean? That means that Germany goes to negotiate with Pakistan. In the 50s, Germany has a model and maybe has, 50 negotiators. Pakistan has 2 negotiators and no model. So the final treaty will most likely look a lot like the model that is there, which is the one from Germany. So a lot of investment treaties that we have today reflect the priorities, the interests, and the models of developed countries. So this is something to keep in mind. So they were mostly north-south for a long time, different from FTAs. There are usually not BITs between north-north countries. what you find are FTAs, because FTAs regulate all trade relations, and then, okay, you also have a chapter on investment. Now, 1990s, 2000s, some countries that traditionally were capital importing have become capital exporting. China, India, Mexico. So they have developed their own models. But you always find this asymmetry because, for example, China has been negotiating a lot of treaties with African countries, but in that specific relationship, China is usually the capital exporting country, and the DRC, Chad, Mali are the capital importing countries. So you always have these unbalanced relationships, usually, in bilateral investment treaties. Now, what I want to do today is to, get to the scope of application, so to see when these treaties apply and the protection offered by investment law applies, and that will require us to look at when do we have an investment and when do we have a foreign investor. But before we get there, I just want to kind of show you a little bit a few preliminary points on BITs. Now, what is the first thing you find in a treaty? You take a text of a treaty, what is the first thing you find? It's not a trick question. There's one page with one thing. Who it is between? More generally, the? Yes?
The preamble.
Before the preamble. Title, which usually involves the parties. Huh? So the title is important. Now, I say bilateral investment treaty, BIT, but that's just a general name to refer to any treaty between two countries on investments. Now, they're not necessarily called bilateral investment treaties. Huh? They can have different names. Just to give you a sense, so this is the, for example, the SADC model BIT is called actually, yes, BIT. Huh? But the one, the Canada model BIT is Agreement for the Promotion and Protection of Investments. German model BIT, it's a treaty between concerning the encouragement and reciprocal protection. So just to let you know that there is a wide variety of different titles. But if you have two countries and the objective and the content is to protect foreign investments, you have a BIT, regardless of the title. Now, you often find this term reciprocal, which is quite funny because based on what I told you earlier, usually the only thing that is reciprocal is the title. You have a treaty between, for example, one of the first treaties to reference to international arbitration is a treaty between Italy and Chad. Now, do you think, so ideally it's reciprocal, right, to protect foreign investors from one country in the other one and from this country here. Do you think that it's to protect Italian investors in Chad or the many investors that from Chad invest in Italy? Usually it's one way, because usually it's a treaty between a capital exporting and a capital importing countries. So amazing, reciprocal, but most likely it will protect the investors of the country that actually sends investors to the other. What comes after the title? Somebody said it earlier. Preamble. Very important, the preamble. I think I've already expressed my love for preambles. As you know, as I've already said many times, preambles are not, bless you, binding. They don't contain any binding duties or obligations or provisions, but they are super important. They are used by tribunals to interpret other provisions of the treaty. So it makes a huge difference what a preamble looks like. And I want to show you because there is a crazy diversity in the kind of preambles that you find. I want to start with the German model BIT. I like to show this model whenever I want to show a model or a treaty that is very protective of investors and investments, because this is probably it's the best example of a model that is really about 100% about protecting investors. If you look at the preamble, it talks about, intensify economic cooperation, but it's really all about protecting investments and investors, right? Creating favorable conditions and contractual protection and so on and so forth. this preamble is telling us that all that matters is that we need to protect investors with this treaty. That's the object and the spirit of the treaty. This can have an impact in cases when maybe the state is trying to regulate, for the public interest, and this regulation has an impact on the investor. Imagine that the state wants to, and this is happening a lot, there's a lot of disputes on this specific issue. A state decides to phase out coal-fired power plants for climate change reasons, climate change mitigation, NDCs, they want to reduce the dependence on coal. You have investors that are operating in that sector that are gonna sue the state, are gonna bring a dispute because that specific decision of the state has an impact, a negative impact on the investment. Now, with a preamble like this, the tribunal will say, you know what, state, I love that you're taking care of climate, this is amazing, kudos, but the whole point of this treaty is to protect investors. Is your measure having a negative impact on an investor? Yes. So unfortunately, I don't care if you're doing this to protect the environment, if you're doing this to protect public health, it doesn't matter. This is what I have to work with. So this is the risk of having this kind of preambles. No? There is now, in particular when it comes to developing countries, that it's very important to advise them not to conclude BITs with these kind of preambles, because then the moment that they want to do something to protect their economy, to protect small and medium enterprises, to do whatever, if you have this kind of preamble, you're kind of stuck, and the tribunal could use it to give a very rigid interpretation of the different provisions. Now we have other types. So this is another example. This is the old Canadian model because they changed it in 2021. The new one is a little bit more sophisticated, but kind of as a middle ground, I wanted to show you this old Canadian model. So here you can see it's very succinct, but it goes a little bit beyond protecting investments and investors, you see. It also talks about the promotion of sustainable development, for example. It's just a sentence. It's not so much, but you can say, okay, it's not just about protecting investors or facilitating economic cooperation. There's also this, importance that is given to sustainable development. So they made a little bit of an effort. Still, we could have better. Now I'll show you my favorite preamble. I actually have a favorite preamble, which is this one, the SADC model BIT preamble. This is much more sophisticated, right? This is very important. So it recognizes the important contribution that investment can make to sustainable development. And this is key, seeking to promote, encourage, and increase investment opportunities that enhance sustainable development. This is to say, this is not about protecting investments. This is about protecting those investments that enhance sustainable development. And it's very powerful language. It shows you that there is, an interest in protecting in particular, if not only, those investments that can contribute to the sustainable development of a state. Then it talks about the pillars, fine. It reaffirms the right of the state to regulate. So it says that states have a right to regulate. So of course we're going to have all these provisions to protect investors, but let's not forget that states also have a right to regulate. And here as well, there should be a balance of all these different rights and obligations of states and investors. So this, I think, is a good example of, yes?
Sorry. And so do the states in practice actually get to implement it and negotiate it?
Very good. So this is just a model, right? So for a long time, you would find this language only in models. Now we start seeing some. Investment. Africa is one of the most progressive countries when it comes to kind of the wording of the provisions. And you actually have in this university, in this faculty professor that has helped negotiating this specific protocol. So it's super long. I'm not going to read through all of it. You have it in the slide. You have it in the syllabus, in the polycopier. But again, you have a lot of references. Once again, here there is Agenda 2030, so sustainable development. At some point, it even talks about responsible businesses. So there is this idea that also corporations and investors should behave in a certain way. It talks about regional development, indigenous people, women. So there's a little bit of everything, which can become also tricky if you put too much. But this is an example of not just being a model, but actually being an actual treaty that has that language. Because for a long time, this is a very good question. And when I started teaching investment law, I only had models to show. And now we actually see it, in actual treaties. So, of course, if you have a more sophisticated preamble, then, the example that I was telling you earlier, for example, if we go back here, and I'm not saying that it would happen, but you're an arbitral tribunal and you have a state that is phasing out coal-fired power plants for climate change mitigation reasons, for example, and you have the investor complaining, and you could say, well, that's not an investment that enhances sustainable development, or at least I should take this into consideration while I am interpreting the different rules of the treaty. So you might end up having a different or a slightly different decision. Everything okay so far? All right, now we get to the juicy part of the session. So usually after the preamble, you have another article which talks about definitions. You have lots of definitions. You usually have the definitions, like in any treaty, of all the terms that are relevant for the treaty itself. And we're going to look at two definitions: investment and investor, because those are the two important definitions that help us determine whether we are looking at an economic activity that is indeed protected by that treaty and by international investment law, because not anything can and should be. Because as you will see next week and in the following weeks, in 2 weeks, the protection is very, very strong. So it's important to select who can actually benefit from this protection. Now, the definition of investment, now the notion of investment is a notion of the modern economy. If you remember, I think the very first class, I told you that the roots of investment protection go back to treaties like friendship and navigation from the 18th century and the 19th century. But they wouldn't talk about investment. They would talk about property, the property of foreigners, assets of foreigners. So this notion of investment is a notion of the modern economy. It's also an economic notion. It's not a legal notion. And treaties have tried to define, but we actually do not have a clear definition. This is get ready, a lot of investment law is this. There's no definition of almost anything. So we don't have a definition of what investment is. It's also because so many things can be an investment. A construction of a highway can be an investment. A building can be an investment. A patent or another intellectual property right can be an investment. Lots of stuff can be potentially an investment. And because the global economy is constantly evolving, and the notion of investment evolves with it. We would have maybe 20 years ago, we would have never imagined the role and the importance of information technology or artificial intelligence today. So we have a lot of activities that we have to protect and maybe consider investment today that didn't even exist 20, 30, 50 years ago. I had a few students that wrote very nice theses precisely on some of these new investments, like investment in digital assets or carbon credits as investment, things that we never thought could be investments, but maybe we should. So we don't have a definition, so don't expect to find a definition. And if I ever ask you in the exam, give me the definition of investment, your answer has to be, there isn't one. But I'm happy to provide an explanation of all the different approaches that we find. It's a very nice way. So what you find is approaches. So you do have something in an article called definition, but it's not really a definition. we like to say that there are different approaches in treaties as to what constitutes an investment. And there are three key approaches. This is the first one, open asset-based approach. Very tricky. Open asset, as the term suggests, means that it's a very open, very broad approach or definition of what an investment is. And I will give you an example. Of course, if you have a very open and broad definition of what an investment is, that means that a lot of stuff falls under the definition, which means that it's very protective of investments, right? Because it's going to be very likely that whatever you're doing falls under the definition. And so, German model BIT. It's always my go-to model when it comes to protecting, investors. This is what an open asset-based approach looks like. The term investment comprises every kind of asset. Every kind of asset. The investments include in particular, and then you have a list. Now, a lot of countries, when they were negotiating with Germany or with other countries that used this in their model, they kind of got confused and fell a little bit into this trap. They saw this list and they thought, okay, it's a kind of a short list. These are examples. What matters is this, every kind of asset. Any kind of asset can potentially be an investor, an investment. Let me give you some examples. And there have been cases, horrible decisions, let's say controversial decisions that have decided that things that, maybe we shouldn't consider investments were investments. One example is, in this case, Mitchell with the DRC. So this was a case that was brought by Mr. Mitchell. He was a lawyer. He had opened a law office in the DRC, which concretely meant that he had rented out or bought, I'm sure about that, a couple of rooms in a building where he was conducting his law business. At some point, the military seized the property, seized the rooms, the space that he was using, and he brought a dispute, saying, "Oh, my investment has been expropriated." He didn't even have clients from the DRC. He was just using the space, but all his clients were foreign. The tribunal found that this was an investment because the applicable BIT is the BIT between the US and the DRC, which says every kind of asset. Well, at the law office, it's an asset. Why not? Later, this was annulled, this decision, because it makes zero sense that this is an investment that should be protected under international law, and we will see why. Another example, this is a very famous case. There's a lot of cases that came out of the Argentinian crisis in 2001, lots of cases. Because, of course, you can imagine, whenever there is a financial crisis in a country, a lot of investors are going to suffer. Now, in this case, who brought this dispute were 160,000 Italian nationals that had probably never set a foot in Argentina, but they had, in the previous years, they had purchased Argentinian sovereign bonds. So they bought these bonds, then crisis, so Argentina had to restructure its debt in a way that was not beneficial to whoever had bought the bonds. And they're saying, well, this was an investment, and it was being expropriated by Argentina. And they relied on this BIT, which has the definition, every kind of asset. And the tribunal said, yes, that is an investment. And this also gives you an idea of the importance of preambles. So it says the list, which you find in the every kind of asset definition, covers a wide range of investments using a broad wording. So the definition is not drafted in a restrictive way. Based on its wording, as well as the aim of the BIT as described in the preamble is very similar to the German model. So preamble that is just about protecting investors. The article with the definition cannot be seen to have intended to adopt a restrictive approach. So every kind of asset plus a preamble that is all about protecting investors, well, that means that we really need to interpret very broadly this preamble because we need to protect investors as much as we can. So yes, this would fall under the definition, yes.
Are there sometimes like restrictions on the kind of prejudice that prejudices the investment that can give rise to a dispute under a PAT? Like for instance, not necessarily like okay, if there is an expropriation, then the BAT can be tackled, but if it were like just a financial crisis, even if the asset can be considered an investment, this could not be protected under the BAT because it would be another way to narrow down.
Very good. Excellent point, and we'll talk a lot about this towards the end. There are exceptions. There are exception clauses along the lines of the GATT exceptions. So sometimes you have language that is very similar to GATT Article 20. Sometimes you have exceptions that are very similar to the national security. So you could use those. So that would mean that your investment is protected, but you're trying to use an exception to justify. There are also other ways. In the case, for example, of an expropriation, you could try to argue that it's an indirect expropriation that is actually a legitimate use of your regulatory powers, but we're going to get to that. But yes, so there are other ways, but of course, once it's a protected investment, then it's really about how the other provisions are interpreted, but we do have exceptions, yes.
Could you please clarify the difference between direct and indirect investment?
Indirect is when it's through an intermediary, which also counts, from another country, for example. So that's the first approach. Again, very broad, honestly quite dangerous. So if I were to advise a government, in particular a developing country, I would maybe try to advise them to stay away from this very open, but to have a little bit more control as to what they put in the definition. A little bit more restrictive, we have the second approach, closed asset-based approach. Now this is, as the name suggests, it's closed, so we're going to have a closed list of assets. So it's not every kind of asset. There is an actual, closed list. It's not just examples. But you will see it's kind of it's almost an open asset disguised as closed, because usually you have very long lists. So this is the Canada Model BAT, and you have, if you look at this list, there's almost everything. So quite often, whenever a treaty adopts a closed asset list approach, closed asset-based approach, yes, you have the advantage that it doesn't say every kind of asset, so you have a specific list, but sometimes these lists are 2 or 3 pages. So they're so long that they have put almost everything. So sometimes they're still extremely broad. But you have a little bit more the predictability that you can check what is in the list. And then we have a third approach, and I'm giving you these approaches from the most popular to the least popular. The most popular you find is the open asset. Then you find this, and then you find my favorite, my personal favorite, which is the enterprise-based approach. China, most treaties concluded by China adopt this approach. NAFTA, for example, so I will use NAFTA a lot. You might ask me why, because now it's no longer in force. We have USMCA, but we have so much important case law that is brought under NAFTA that I will still use it a lot. So this is an enterprise-based approach because you need an enterprise. You always need an enterprise. You need a commercial presence in the country. So with this definition, the ABACLAT Argentina would have been decided very differently. Those 160,000 Italian nationals did not have a commercial presence in Argentina. This is my favorite because you really make sure that you contribute to the economic development of the host state. Yes?
How is enterprise defined?
I don't have it. I can pull it out during the break. What matters, we will see, is the nationality of the enterprise, which will differ from country to country. Well, there is a definition of enterprise for sure. So I can get the whole treaty during the break. By requiring a commercial presence, by requiring to have an enterprise on the territory, that means that you're going to pay taxes. That means that you're going to employ people. So you're going to contribute to the economy of the country. It falls more under what an investment that merits protection should look like. But so you have, and do I have another example? Yeah, here you have another example. So the investment protocol of the AFCFTA as well. It's drafted differently. Here you have enterprise basically mentioned every time. Here you have it at the beginning, and then you have a list. And then the list is usually a closed list, but it can also be open. But you need to have this commercial presence. So these are the three main approaches, okay? Open asset-based approach, closed asset-based approach, enterprise. There is then a variation. I think the Italian model BIT from 2022 uses it, which is to have, for example, the open asset, but then have some exceptions. So you use the open asset-based approach, you say every kind of asset, such as blah, 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 and then you have some paragraphs that say, but these do not fall under the definition. That is, kind of a fourth, it's less used, but we start seeing some models that try to do this. So they use the more traditional open asset-based approach definition, and then they clarify some assets that are not to be considered as an investment. Everything okay so far? All right, so this is the treaty definition or treaty approach to what an investment is. So you're an arbitral tribunal. You need to determine whether your jurisdiction, whether the economic activity is indeed an investment. You're going to look at the applicable treaty and you're going to say, okay, is this an investment based on the definition? Okay, I still have a little bit. Okay, I'm going to complicate things for you. This is true only if the arbitration is outside of ICSID. We will see there are different mechanisms. ICSID is the International Center for Settlement of Investment Disputes. So let me go back a second. Disputes are decided by arbitral tribunals or investment tribunals. Very different from WTO. Usually, the investor chooses one arbitrator, the state chooses a second arbitrator, and then the two choose a president of the tribunal. And then you have this usually 3-person tribunal. You can also have a 1-person, rare. Usually you have a 3-person tribunal that decides the disputes. When the dispute is over, the tribunal is dissolved. But we have different mechanisms and rules that regulate how these tribunals operate. One of them is this. So there is this center. It's based in Washington, D.C. It's actually an organ of the World Bank. And it's not a tribunal, but it kind of takes care of the logistics, the finances, the payments, and it has its own rules. There is an ICSID convention that we will look at. We have a whole session on arbitration that tells you how arbitration under ICSID needs to operate. It's the most used. Most disputes are under ICSID rules. The second, very common, is UNCITRAL, which is the United Nations Conference on International Trade. This is also very much used. And then you have the ICSID additional facility. Again, we're going to talk in detail about arbitration later on. That is for disputes when one of the two, either the host state or the home state of the investor are not members of ICSID, And then this is the Stockholm Chamber of Commerce, International Chamber of Commerce, and others. But the main mechanism is this one, is ICSID. And again, we will look exactly how these rules work later on. But if your dispute is under one of these mechanisms and these rules, the arbitral tribunal will simply have to look at the definition of investment in the treaty, and if your activity falls in that definition, it's an investment. If we are in the context of an ICSID arbitration, there is one more step. There is a second test. It's not enough that the investment is an investment under the treaty. It also has to be an investment under the ICSID Convention. And this is because of this provision, Article 25. This is just one paragraph of Article 25 about the jurisdiction of the center. You see, the jurisdiction of the center shall extend to any legal dispute arising directly out of an investment. Because it talks about investment, a tribunal will have jurisdiction under ICSID only if the investment is not just an investment based on the treaty, on the applicable treaty, but is also an investment under the ICSID Convention. It's what we call the double keyhole. It's like you have a door and you have two keyholes that you need to open, or the double barrel test. So there's two steps in the test. Do you think that the ICSID Convention contains a definition of what an investment is under the ICSID Convention? Would be easy, would be nice. It does not. States thought, you know what, when they were negotiating ICSID, they were like, you know what, I think states should have flexibility. So let's clarify that it has to come out of an investment, but let's not say already what an investment is. So if you're an arbitral tribunal under ICSID, you need to determine that the investment is an investment under the applicable treaty and under the ICSID Convention. But how do you determine whether an investment is an investment under the ICSID Convention? This is where tribunals are necessary in international investment law, because it's actually an arbitral tribunal, in this case, Salini, Morocco, that told us what are the factors, what are the criteria that have to be there for an investment to be an investment in the sense of the ICSID Convention. It's a decision from 2001, and it was so landmark that we call this test the Salini test. Let's take a break, and then we come back, and I continue with the Salini test. Let's do 3. What time is it? 3. Yeah. I don't know. 3:17, 18, almost 3:20. Let me look for now.
In the Sykes documents that we had for last week, there was this sentence that I was disturbed by. When talking about prohibited subsidies, it stated that all such subsidies are defined to be specific regardless of the details. So I didn't understand if we had to state the specific.
So if there was this in the Article 2 on specificity, you have first enterprise specificity with 3 types, then you have regional specificity, and then the last subparagraph tells you that prohibited are deemed specific. That means that if you have a subsidy that is either based on local content or export subsidy,
Yeah.
it's irrelevant
If
if it's specific or not. It's considered to be
It's
specific.
because it's the third
It's the third
paragraph.
one. Those are just, you don't have to go to the specificity.
But is it like a presumption? Or
Yeah, it's
Okay.
they're just so bad that it's irrelevant.
Okay.
If they're specific or not.
Thank you.
But it's a very good point.
So, Professor Thomas Schultz, he said that he talked about how international investment happens. And he said it's always between the state and the private. Once the decision is taken, and it has to be enforced by another state. But since we discuss about the public, there is a regulation second that explains all the obligations and values that one of these is that no state has the right to intervene in internal affairs. How do you reconcile enforce the judgment that affects the economy of the state? So it's we seize the assets of the debtor state.
But they have to be
Only commercial assets that are in foreign countries. Yeah. Okay, so in that situation, let's say for example, state A has assets in state C, D, E. In order to enforce that judgment that arbitral award, you have to recognize that award in C individually. Yeah, the reward convention. Yeah. What type of tools that the state has to defend itself from all this system that it's so biased in a way, it's so in favor of investors?
We will have a whole session. Politics of that is, I mean, investors arbitrators that are going to decide the way we sometimes they because they feel
Since we talk about all of these things take place, it's always outside of arbitrary institution. So the exit is
it's a sector that offers people
I mean, the institutions form those small group of people, right? Then it's just between the state and the investor in order to choose those 3 people. They choose the others. Okay, okay. That's very nice.
rules are very different. Each city rules are very different. Sometimes
that's the thing, because I was wondering for this type of disputes, then the law applies is the law of the institution and insurance, for example, the exit law. Yes, yes.
But then the substantive law is going to be
It's a part. Yeah. So, for example, the treaty have something to say no, about the marriage.
the next section, you're going to work on all the substantive provisions.
Yes, I get it. It is more clear if we are following at the same time international arbitration law and it's very interesting. Thank you very much.
One, how is the national finance? And second, because I'm going to visit the country of corporation. And the other question is how big is the contract between investor and country?
Actually, he asked me to take your place. Oh, wow. And he was talking about you enjoy the class, you must take the class.
So you started, you just started.
Yeah, I just
Okay, but look, you know, whenever you want to see me, the
I was actually planning to write you a letter, and she asked me if she could take a picture.
Like, I was like, do you know this person? You know the picture on the board? I'm like, do you know this person? She's like, no, I don't know. What you would have like, you didn't know it before.
I told her that please do not I told her that was Jesus.
you might remember that.
Yeah, I met her once.
Yeah, okay, because the minister tried to
I decided on the like kind of what's up we have. So he messaged that you like and also Eleanor replied like we are in the same team like it's not that I don't see
buy economically. All the others are like better on the globe. I met 2 of them in Singapore. I got. It's tough, huh? You come to the WTO or something, right? Yep, yeah, very good. It's gonna be fun. It's gonna be fun. Oh my God. But it was great to meet you. Write to me so that you can come see me, we can chat, you know. All right. So I just pulled out very quickly the definitions of NAFTA. One of you was asking about how it defines enterprise, right? And so you also have, enterprise, entity, constituted, and here you have a little bit of a definition. What will be important later on is this one, enterprise of a party, because this is the definition of how, at least how NAFTA looks at the nationality. So this is going to be an important point. But if you go on the definition, you will find definitely a definition of what an enterprise is. I had a lot of excellent questions during the break, in particular about the rules that govern arbitration. For the time being, again, we're going to have a session where we're going to look at those, but just for you to have an idea, usually a treaty, a BIT, or an investment chapter in an FTA has an arbitration clause that tells you which of these mechanisms can be used. So there can be, for example, and we will see in the next session, when we talk about MFN in the context of investment law, we'll see that some arbitration clauses, for example, allow you to go to all of these. Some only allow ICSID, so they're very different. Some of these clauses tell you that the investor can choose where to go. Other times, the investor has to agree with the state, so they can vary. Contracts also have an arbitration clause, usually, and so an investor usually investors can choose to bring a treaty, to bring a dispute under the contract or under the treaty, depending on whether they want to claim that the state has violated a provision of the contract or in the treaty. So depending, if they bring in a treaty claim, they will have to rely on the arbitration clause in the treaty. If they bring in a contract claim, they will have to rely on the arbitration clause in the contract. Then the tribunals will apply the treaty or the contract, depending. And then the rules, for example, the ICSID rules will simply govern the procedure. They tell you how the arbitrators are selected, what kind of characteristics they have to have, how long from a hearing to another, things like that. The award, by the way, is the name of the judgment or decision is called award because it awards a monetary compensation. So, but just to give you a sense, but we will get, don't worry because we will talk about the procedures and arbitration later on. Now I wanted to tell you a little bit about the Salini test. So, as we said, when we have an arbitration under ICSID, the tribunal has to do this double-barreled procedure. So first look at whether the investment is an investment under the applicable BIT, and second, whether it's an investment under the ICSID convention, which generally means apply the Salini test. Now, this is a dispute that was brought by two Italian construction companies against Morocco. The contract that was at the heart of the dispute was a contract to build a highway. And here you have the whole, a lot of the discussion revolved around whether the construction of a highway was or not an investment. And this is what the tribunal told us. The doctrine generally considers that investment infers contributions, a certain duration of performance of the contract, and the participation in the risks of the transaction. In reading the convention's preamble, and here it's talking about the ICSID convention, one may add the contribution to the economic development of the host state as an additional condition. So 4 criteria. The first one, we call it a substantial contribution. So it cannot be merely symbolic. It has to be substantial. More often than not, it's a financial contribution, but it doesn't have to be. It can be also a contribution in kind. It can be equipment. It can be goods, services. I signed a contract with the Minister of Education of Brazil to sell 10,000 office desks and chairs. It's not financial, but it's a substantial contribution in kind, equipment, for example. Secondly, it needs to have a certain duration. Now, there are no upper limits, of course. There's not a minimum either. Generally, tribunals consider a certain duration somewhere between 2 and 5 years, generally. In this specific case, the contract had a duration of 36 months. But there have been tribunals that have considered that 5 or 6 months is also enough. Now, what you want to avoid is a one-off transaction. Like the example that I gave you wouldn't qualify as having a certain duration. I'm selling you 10,000 shares, done. So it wouldn't be an investment already because it's failing the second element. The third element is that there has to be a risk. Now, this is a criterion that actually it's there, but it doesn't have a lot of relevance because tribunals usually consider that anything can be a risk. Now, in this case, for example, the activity, the transaction was the construction of a highway. Now, what is the worst thing that can happen? That the government doesn't pay you, that it pays you late, that it doesn't pay you as much as you had agreed. That's a risk that is, whatever you do, there is always this kind of risk. It's very different from, say, I sign a contract to explore and exploit oil fields. I might not find any. Very different risk. And you can find authors that go kind of in one or the other direction, but generally tribunals consider that any economic activity usually has even a small risk, that's fine. So this is a criterion that is there, but it's not very important because it's always there. Now, these three criteria are well established, and you can see the doctrine considers. So these are not, these are well established in the doctrine. It even cites a famous arbitrator. So these are quite established. No tribunal would not look at these. The fourth criterion, it's an invention of the Salini Tribunal. They looked at the convention preamble that talks about promoting investments to promote the economic development of the state, and they said, well, this should also be a criterion, but they came up with it. And this is much more controversial. There are some tribunals that have embraced all four criteria. We call them the Salini tribunals because they follow the Salini test and they look at all four elements. But not all of them do. Now, you remember this case I showed you earlier, the guy that had this law firm in the DRC. Now, the award of the tribunal that found that it was an investment was later annulled. Again, we will talk about the procedure of annulment of arbitral awards. So there was a committee that was set up to review the award, and this committee said, this is not contributing to the economic development of the DRC. In no way. So it cannot be an investment, and it annulled the award. So that committee embraced the entirety of the Salini test. This is another nice case. Here the activity was the salvage of some, ancient artifacts from a shipwreck. And it was considered not to contribute to the economic development of that country, and so not to be a tribunal. Sorry, it's been a long day already. Not to be an investment. So these are just two examples of arbitrators that have embraced all four criteria of the Salini test. But you can also find tribunals that will only take the first three, and they will not take the fourth one. Some countries have even modified their models to make sure that the fourth criterion is not applied by a tribunal. The US model BIT. Now, I want you to look at this definition of investment, and I want you to tell me there are two ways. One is easy, one maybe a little bit less easy. Two ways in which the US is actively departing from the Salini test, which means that any tribunal that applies this, a treaty with this definition won't be able to do certain things. One is easy, one is less easy, but I think you can do it. What are the criteria that we have? We have the commitment of capital or other resources. So that's your substantial contribution. Then the fact that you're expecting something, it's a stretch, but it has been looked at duration. And then you have a risk. What is missing? Contribution to the economic development. But there is also another difference. Let's go back 1 second. Contributions, comma, a certain duration and a participations in the risks and an additional. Or, so in the Salini test, those are cumulative. You need all four. Here, they remove the fourth and they make them alternative. Meaning you have a contribution, but you don't have a risk, bah, tampi. There are alternative criteria. So this is an example of, so you have the Salini tribunals, so those that follow blindly the Salini test, the anti-Salini tribunals that usually do not accept criteria number 4, and then you have even some countries, they want to guide tribunals into adopting one of these, in particular in this case, making sure that a tribunal will not follow the Salini test. But again, Salini, remember, only for ICSID cases. So a tribunal under ICSID will have to say, okay, is it an investment under the applicable BAT? Yes, great. Is it an investment under the Salini test? Contribution, risk, duration, yes or no? The fourth one, if it's a yes, okay, we have an investment. The first element that determines the scope of application of the treaty is, exists. Everything okay? All right, so definition of investment, it tells us the scope, the objective scope, I don't want to use too much Latin, but the ratione materiae scope of investment law. Somebody was asking me about foreign investors. Now we also need to define who is a foreign investor. You can have an investment, but this investment has to be made by a foreign investor. This gives us the definition of the scope ratione personae, subjective scope of application of our protection. Now, I said earlier that investors are usually both, they can be either individuals, I can be an investor, or companies. In both cases, what matters is the nationality. Now, the nationality is crucial for two things, two reasons. First, it gives us, or it tells us the foreignness, I don't know if you can see, the foreign nature of the investor and the investment. The nationality here tells me that my investor is from country B and not from country A. Because if you are from country A, if you have this, if you have the same nationality as the country where you're investing, you are a local investor. You do not deserve protection from international investment law. Domestic law applies. So that's the first reason. The nationality helps you determine if it is indeed a foreign investor. What is the second reason why the nationality matters? Can anybody think of a second reason why I'm investing in Canada? It's important to make sure whether I'm, I don't know, Mexican or Brazilian.
Which agreement?
Excellent. Which agreement applies? So let's say that I'm Mexican, I invest in Canada, USMCA applies. So it is United States, the one that has replaced NAFTA. So it tells me that I am not Canadian, so that I have a nationality different from the country where I'm investing, and it tells me that I'm Mexican, so it has to be a treaty between Mexico and Canada. If it turns out that I am from Poland, it's going to be a different treaty. It's going to be Poland-Canada. With all the differences that the treaty, because treaties are similar, but they're not the same. Let's start easy. Yeah, this is something interesting as well. Because not all countries are also parties to the ICSID Convention. So that's also where the nationality helps. Because I will show you a case in a second where with Canada. In Canada, for example, I think Canada joined ICSID, I think in maybe 2006. But before that, if you were a Canadian investor, you couldn't benefit from ICSID rules because your home state is not party to ICSID. So it also determines whether you have access to ICSID. So that's also important, the nationality. Now let's start easy. Individuals. How do we determine the nationality of an individual? Something we all have. The Swiss one is very pretty, it's red. passport. Easy, right? So it's, of course, every state decides what are the criteria to give its own nationality to an individual. But then once you have a passport, you are a national of that country. Easy, but not always so easy. There have been some crazy cases. This is one of them. Now, this Soufraki guy, he had some issues with the UAE. He was in the UAE with doing some business. He had some problems, and he brought a dispute under the Italy-UAE BIT with his Italian passport. Say, I'm Italian, look, I have a passport. I go to ICSID because both Italy and the UAE have ratified the ICSID convention, and this is the treaty that applies to me. Now, the tribunal has to do a little bit of research, and they found out that actually in the meantime, our friend Soufraki had obtained another nationality, the Canadian one. There were some rules for how he had obtained the Italian nationality. He had to be a resident for a certain number of years. So in the meantime, he had lost the Italian nationality. But nobody had informed Italian authorities. So he still had his passport. I mean, don't even. But he wasn't actually an Italian citizen anymore. He was a Canadian citizen. And this was 2004, when Canada was not a party to ICSID. So he didn't even have access to ICSID arbitration. So it's usually easy, but it's important for the tribunal to do a little bit of digging to make sure that there is an actual, that the passport actually reflects the nationality. What happens? What do you think happens if you have more than one nationality? What do you do there? Somebody has an idea of what you could do? You can choose. So for you, the investor chooses. You're very protective of investors. Okay. What else? What are other options?
Maybe with which you have the closest relation.
That's usually what happens. It's a principle of effectiveness. So with which one is your effective nationality? Let's use what I was saying earlier. I have a Mexican passport. I am investing in Canada, but I also have a Polish passport. So, USMCA or Canada, Poland, BIT? Well, I've never been to Poland. I don't speak Polish. I got the nationality because some grandmother was born in Poland, while I've lived all my life in Mexico. I raised my children in Mexico. I do everything. My effective nationality is going to be Mexican. Mm-hmm. What if I have the Mexican nationality and the Canadian nationality? So one of my two nationalities is the nationality of the state where I'm investing. Immediately we could say, well, the same principle, effectiveness. If your effective nationality is Mexico, so a different nationality from the state where you're investing, you should be able to be a foreign investor. If your effective nationality is Canadian, you're, a domestic investor, really. Outside of ICSID, that's what happens. Outside of ICSID, if I have a Mexican passport, a Canadian passport, I am investing in Canada, but my effective nationality is Mexican, I am considered a foreign investor. Outside of ICSID, in ICSID arbitration, if I have among my many nationalities the nationality of the country where I'm investing, so the host state, even if it's not my effective nationality, I cannot be considered a foreign investor. This is again Article 25. I showed you the first paragraph earlier. Now the second does not include any person who on either date also had the nationality of the contracting state party to the dispute. It doesn't matter if it's not your effective nationality. If I am a Mexican individual invested in Canada and I happen to have a Canadian passport, I cannot use ICSID. That doesn't mean that I can pursue other routes, because there are, again, other mechanisms where I will be considered a foreign investor, but not by ICSID. So it's a little bit more rigid here. Everything clear? Because now we move to corporations, and corporations do not have passports. It's a little bit more complicated. One of you had asked me during the break, what do you do for corporations? Once again, treaties adopt different approaches. Most treaties tell us that, and this is, for example, what we had in the NAFTA that I showed you earlier. Most treaties tell you that an investor, an investor corporation, has the nationality of the state where that corporation is incorporated. So it uses the criterion of incorporation. Where it's incorporated, that means where it's registered, under which law it's registered. Which domestic law has given the corporation its legal status as corporation. Very popular. I don't know if yeah. German model BIT, of course. Oh. Okay. Natural, juridical person, la da da, which is founded pursuant to the law of. So it's simply where you incorporate. Even if you don't have anything there. There are some countries where it's very easy to incorporate. The Netherlands, for example, very easy. You go in the morning, you come back in the evening, you have incorporated your enterprise. And there are many cases that I didn't put them just because I didn't want to, give you too much. But there are many cases where you would have a company that was incorporated in country A, but it was entirely or 99% controlled by nationals of an entirely different country, and yet the tribunal relied on incorporation. So it doesn't matter if it's entirely controlled by Japanese, if it's registered in the Netherlands, it's a Dutch company. They have been very reluctant to pierce the corporate veil, tribunals. Now, of course, again, as I told you, it's quite easy to incorporate a company in certain countries. So a lot of investors pick and choose. And that's legal to a certain extent. You say, well, you know what? I would like to build a highway in Morocco. Can you please look and tell me all the BITs that Morocco has? Which one is the most favorable for an investor, particularly in the construction sector? Oh, it's the Morocco-Belgium BIT. Fantastic. How does it work to incorporate a company in Belgium? Because I'm going to incorporate there. Then if I ever have a problem with Morocco, I will have a very beneficial, favorable treaty to apply. This is not unlawful per se. There are law firms that do a lot of this work, actually. But there can be abuses. So it's important to avoid abuses. And I will give you an example of a beautiful abuse. This was actually, I started studying, actually, because I started studying investment law fairly later during my master's, and this was the first case that was assigned to me, Phoenix. I was like, what am I doing? What is this? When I read this case, and you'll see why. So there was a guy, a Czech national, a guy from the Czech Republic. He had a business in the Czech Republic. His company was called Phoenix. He got into trouble with the Czech government, some tax problems. He was a local investor, right? So what could he do? Not much. So what does he do? He sells his company to his wife for like $4,000. He moves to Israel. He incorporates a new company in Israel and he calls it Phoenix. He buys his wife's company and he sues the Czech Republic under the Israel-Czech Republic BIT as an Israeli investor. This was my very first case that I ever read. I was like, what is this? And thank God the tribunal understood that this was an abuse. And I have, we have in the syllabus some very nice paragraphs from the award, you see? So the claimant made an investment not for the purpose of engaging in economic activity, but for the sole purpose of bringing an international litigation against the Czech Republic. That was the only purpose. The unique goal of the investment was to transform a pre-existing domestic dispute into an international dispute and then benefit from this beautiful protection of investment law. It's not a bona fide transaction. And again, it continues. It really goes on and on because this is important. It calls it, it's an abuse. Creation of a legal fiction in order to gain access to an international procedure. Abusive distortion. So it uses quite strong words. And here again, it tells you the claimant's initiation of the arbitration is an abuse of the system of international ICSID investment arbitration. So again, you are free to shop, but there are limits. A case like this, it's a clear abuse of the system. But this is the most popular approach or criterion, looking at the state of incorporation. Now, it's not the only one. Very rare, but there are some treaties that use the siège, so the seat criterion. It's where you have established your seat, which is basically where you have your board and your executives. Now, this has some level of artificiality as well, because quite often the seat is chosen in a country that is interesting for tax purposes. So you have maybe companies that are incorporated, in the Netherlands, but have the seat in Switzerland. And because of the different rules on taxation, usually, you end up paying taxes in Switzerland, which is more beneficial. So it gives, again, there's a level of artificiality because you end up having a nationality not of a country where you're really doing anything. And then there is a third criterion, third approach, which is the substantial business activity. So that's where you have the nationality of the country where you conduct your substantial business activity. And then you have some treaties that use all three. Switzerland loves to use all three. Look, legal entities which are established under the law of that contracting party, incorporation, have their seat, criterion of the seat, together with real economic activities. So basically, for this to apply, if you're a Swiss investor, you need to be incorporated under Swiss law, to have your siège in Switzerland and your substantial business activity in Switzerland. Otherwise, you cannot benefit from this. I like this. Prevents abuses. Again, one day you'll be advising a government. It's not a bad approach. It really prevents abuses. But again, it might be hard because, again, you might have countries that are not happy because they want their investors to be free, to incorporate wherever they like and still be protected. Is everything clear? Yes?
Question. Like, as you mentioned, if a state is not, has not ratified
ICSID.
yeah, and they have another agreement, arbitration clause. So what is the point of not, ratifying ICSID? And what about that the ICSID is noted towards some partner states? Because another example of Asian country, there could be a case where Pakistan was imposed one of the highest penalties, like $6 billion as a award fine to Pakistan, whereas it is considered one of, like it was a German company used their power to influence ICSID tribunal, and the 1 year's IMF debt was exactly of the same amount, $6 billion.
Yeah.
So Pakistan ratified ICSID, India never ratified
Mm.
it because they thought, so
What would push? I mean, there could be, I don't know exactly, but there could be reasons. For example, you know, and again, when we talk about arbitration, we'll see the differences between the procedures. But for example, ICSID, the ICSID rules are very dense, so there's very little that is left to the parties. While under some ad hoc arbitration, under, for example, the ICC or the Stockholm Chamber of Commerce, parties have more freedom to determine the seat of the arbitration for a lot of different things. So I'm assuming, you know, that there might be countries, for example, that don't want to have the risk of having their investors or their state, you know, going to ICSID because of all these reasons. There could be also ideological reasons for the role of the World Bank, because it is, after all, an organ of the World Bank. So there could be, reasons behind, possible influences or things like that. It's interesting. I mean, I've never looked into the specific reasons why a country would not ratify ICSID, but there could be a lot of different, I think, points. But you made a good point that also that being the World Bank, it plays a specific role. So that could be. What is the case that you were mentioning with Pakistan?
The Recording case, it's mining case.
It's a mining case.
Yeah,
Okay.
One of the investor was Katiyat company.
Okay.
This from German, but later on they sell it to other companies.
Okay.
Wrote the case to the ICSID tribunal, whereas it was challenged by Pakistani Supreme Court that it is they violate, they declared it void the agreement because they thought that since the clauses are unfair, so Supreme Court just nulled the agreement and they brought it to the tribunal, and they find the heaviest, one of the heaviest penalties as a award, it's $6 billion as fine to Pakistan. So it was very.
Yeah, and you have a lot. I mean, again, we're going to have a whole session on arbitration. Arbitration, we'll see. So next week there is no class, right? It's semaine de lecture, but we will get to the substance, and you will see that there's a lot of, problems and controversies, but the main criticism are against arbitration, and we will see what are all the different issues. And some of these awards are huge. Sometimes there's 20, 30, 40 billion dollars. And, one thing is if it's against, a very powerful country. One thing is if it's against, Vanuatu, How can you even... so there are a lot of different criticism, and the system is a little bit in a crisis. There are attempts to reform, which are not going very far, but it's a very good point, and it would be actually interesting to see. I've never looked into that in detail as to specific motivations of countries not to join ICSID, but the vast majority has. But it's true that there are quite a few important countries that have taken longer or that haven't. And again, these are not purely legal questions, but if there are any of you that also have maybe a political science background or in your bachelor, or that you want to look into this for a thesis or something, looking into why, for example, why this, or why some countries are not concluding BITs. There is a lot of debate. I had a student that wrote something very nice on to what extent having BITs attracts more investments or not. Do you need BITs really to attract investments? Or because there are, Brazil for a lot of time has not had any BIT, and they were receiving a lot of investments. So again, these are not purely legal questions, but there are a lot of interesting questions that come up. It's a fascinating subject. But enough for now. I'm going to let you go a little bit early, which I think is nice. And so no class next week. I will see some of you on the 4th for the visit. We will send directions, and all the others, we will see each other in 2 weeks to continue our journey in international investment law. license down is basically if we kind of like specialities. So they would have to apply. Very good point. I will actually be next time. Yeah, so they have something created some kind of like specialities, meaning that a tribunal would have to disregard the civil test and apply just the treaty. Because the treaty is actually derogating from the civil test. You might have arbitrators that maybe write dissenting opinions or that have something to say about it, but that's the purpose, is to create something that can derogate from the civil test. Yeah.
But I would say, but will this tax like undermine
Yeah, of course.
the exit condition?
But it also you have to balance with the states are so sovereign they should be able to also. But yes, I agree with you. For me, it's like it doesn't matter if you don't like it, you know.
Okay, so I was wondering, does the exit convention like give the opportunity for states to return? No. Okay, so actually this does not even written in the exit convention, but the practice just shows
Yeah,
that.
I mean, you make me wonder. I don't think it allows for. I don't think it allows for reservation.
So it's just like a new opportunity.
Yeah, it's. First of all, just in the model. So it's a model. It's not in a treaty. I don't think there are cases that I looked into, but I think it would have a tribunal. I can totally see a tribunal that says this derogates from there is already so much debate regarding the fourth material, right? Because the fourth material is not accepted. So I could imagine a state tribunal saying, well, these two states have decided specifically to go in a different direction from what the society decided. So I can expect that because it doesn't really come from the convention, right?
Yeah.
It's how it has been interpreted in the yeah, it is again, it kind of creates this unpredictability, which is one of the issues. But it's not, if you're worried about this, get ready for the next issue, because it's even more disturbing. It's a lot of, very controversial area. Right. Yeah.
So, no doubt that it's very useful to work with international law.